I suspect that everybody is on this call because we're concerned about the state of the environment and the state of nature. And I think we've all watched over the past number of decades during our own lifetimes as we've seen the Earth's ecosystems, we've seen species begin to collapse. Rates of species extinction are far above natural background levels. Ecosystems are declining around the world. We see this with things like deforestation, die-off and bleaching of coral reefs, and other kinds of ecosystems that are facing rapid decline. And, of course, we're seeing the acceleration of climate change. All of this, of course, is happening, and I'm going to say it out loud, everybody. This has all happened pre-President Trump. So for all of us who are very worried about the current administration, believe me, I share that concern, but understanding that all of the stuff that's happened with the environment occurred and were set in motion before he was ever elected to office. So we can talk about him if folks want to, because we've obviously been getting quite a number of calls and concerns about the new administration, but we're really talking here about a system that's long been in place that has led to the natural systems of the earth really falling apart. And I think that's very much what we're seeing now. And that system that we're living under today is not only a system of environmental laws, it's overall legal systems in the United States and really around the world, which have a goal that is very much aimed at endless growth and production, endless extraction, endless development. That endless kind of growth is dependent on the destruction of the natural world. And we're seeing legal systems that not only have environmental laws, which facilitate extraction, which facilitate endless growth, but also have systems of corporate law and other laws that facilitate, promote, and protect that endless growth, which is inherently unsustainable. And so we face a very systemic problem. It's not just that our environmental laws are legalizing things like fracking and GMOs and sewage sludging. It's that the overall legal systems that we live under, both environmental laws and all the other laws, that are aimed in a very unsustainable direction. And the impacts of that are being felt around the world today. And so we have to look at not only our environmental laws, but the system overall itself. And today, as many of you know, environmental laws treat nature as property. That it's essentially treated as an item of commerce and does not possess rights. It's considered to be rightless. So if we draw comparisons when slaves were treated as rightless under the law, they did not have rights. Indigenous peoples, women, have all been treated as rightless under legal systems, and therefore they were unable to defend their own basic rights to life and well-being. And similarly, today we treat nature under the law. And we find that our environmental laws have proven to be wildly inadequate to protect the environment. And that makes sense when we hear that. When you first hear something like our environmental laws don't protect the environment, that can be really jarring. But as our organization, the Legal Defense Fund, has experienced, and I know so many of you in your communities have experienced, that environmental laws are actually legalizing the very things we're trying to protect our communities from. So for the folks in Pennsylvania and Ohio, so much attention and effort and work has been focused on trying to stop things like fracking and pipelines coming in. In Oregon, you have banning things like GMOs from coming in, and in Coos Bay, fossil fuel infrastructure projects from coming in. In New Hampshire, we've had water privatization coming in with Nestle and USA Springs and other companies. All of these wildly unsustainable corporate projects trying to come into our communities that we find we cannot stop under the existing legal system because the existing legal system legalizes these activities. So they legalize that kind of extraction and growth and development. Rights of nature laws begin from a very different premise than our current existing environmental laws. So rather than legalizing these inherently unsustainable activities, they actually begin in a different place, meaning that they begin in a place that first and foremost The laws are to protect the rights of ecosystems, the rights of natural communities to exist and to thrive. So the right to life, the right to basic well-being, the right to be regenerated and restored. So rights of nature laws begin from the place that human activities cannot interrupt the health and well-being of an ecosystem, so the ability of an ecosystem itself to thrive and to flourish. So rights of nature laws then prohibit activities such as fracking, such as sludging, which would interfere with the ability and rights of an ecosystem to fulfill its own rights, its own right to life and well-being. So that draws a strong contrast with environmental laws, traditional conventional environmental laws, which generally focus on regulating how we use nature, how we use an ecosystem, and the conditions under which we can use it, under which we can blow the top off a mountain or drill frac wells under the Marcellus Shale. So rather than regulating how we use ecosystems, rights of nature laws are recognizing that these ecosystems have the right to life and well-being. And they also come from a place where rights of nature laws require, unlike most traditional environmental laws, so not only are you beginning at a place where bad things, unsustainable, ecosystem-harming activities would be prohibited, they also require that in the event that there is harm to an ecosystem, which violates the rights of that ecosystem to live and to flourish, that the ecosystem has the right to be fully restored, so brought back to whole. And monetary damages need to be awarded in the amount that would bring that ecosystem back to whole. That's very stark contrast with most conventional environmental laws, in which you read about in the newspaper, in which we talk quite a bit about at the beginning of democracy school, in which you see companies negotiating with the state government or the federal government, negotiating the fines they have to pay for violating an environmental law, whether it's dumping or emitting above and beyond the already allowed amount that they're allowed to dump or emit, that they negotiate what their fine will be for violating an environmental law, and that has nothing to do. Those fines are not calculated with the amount it would take to actually restore the ecosystem back to whole. And so traditional environmental laws today, not only do they legalize harmful activities, they give you a slap on the wrist if you should violate those. In essence, is what happens. Rights of nature laws, of course, begin in a very different place. The premise that the ecosystem has the right to exist and to flourish, and that activities that would harm it, that would violate those rights, are prohibited. And should harm occur, we have to bring that ecosystem back to whole. That is, to help it fulfill its rights once again. And the last piece that I'll say about how these laws work is that, again, in stark contrast with conventional environmental laws today, where you have to prove that you have standing to actually try to challenge an environmental law or an activity that has occurred under a law. Essentially, it's, we say that nature, under rights of nature laws, has automatic standing. It automatically has the right to defend itself. And that people bring either enforcement cases or defense cases, in essence, to stand in the shoes of an ecosystem. So unlike traditional environmental laws, rights of nature laws do not require that you or me have to demonstrate our own personal standing. That is, that we personally have experienced injury by virtue of injury to an ecosystem. In the case of under rights of nature laws, it's the harm to the ecosystem that is the concern, not the harm to me because the ecosystem's been harmed. And this is a very different place. And so now, of course, and we can talk about, I don't know if there's anyone here tonight from Western Pennsylvania, perhaps from Grant or Highland Township, but there we are representing ecosystems, representing them as they seek to intervene in cases that have been brought by oil and gas companies to override those community bills of rights, which establish that the rights of nature within those communities. And we are now representing an ecosystem, watershed ecosystems, so that this ecosystem can defend its own right to exist and flourish against a corporation that wants to come in and violate its rights. So these are very much first-in-the-nation pieces of litigation that are going forward. So rights of nature laws begin in a very different place, necessarily, because we see how existing environmental laws, which begin with the idea that nature is property, that we regulate the use of nature and everything flows from there, under rights of nature laws, you begin at a place where the focus, the intention is the protection of the right of the ecosystem. And And, to put it into a little bit of context, what we're talking about when we're enshrining rights or securing rights of nature or ecosystems, it's expanding the body of legal rights. For so long as we talk, of course, in the organizing and within the democracy schools, under the U.S. Constitution, the only people who are recognized as having rights, as we know, are white men of wealth and property. And then the body of legal rights, that is, who was actually recognized as having rights under the law, that began to expand because people's movements began to fight against the existing structure of law. And so with abolition of slavery, we saw rights being recognized for African Americans, or at least African American men, in terms of their right to vote. But you see them being transformed from considered slaves and thus property under the law to being rights-bearing people. You see women, the suffrage movement, the women's rights movement, pushing against the existing structure, forcing them to break open to recognize that women have rights under the law, not only the right to vote, but the right to divorce, the right to earn and keep their wages, the right to have custody of their children, a wide range of rights. And that body of legal rights, if we can envision this growing, expanding body, it keeps getting pushed open further and further by essentially people demanding that it be forced further and further open. In our own time, of course, not only as we have the civil rights movement, which pushed it open even further, you have people who advocated for same-sex rights, and they went all the way to the Supreme Court to bust open further that body of legal rights to recognize further others who haven't been recognized as having rights before under the law. There's a parallel, I think, that we can draw with human rights. And so, with human rights, there's considered by many this idea that there's 3 generations of human rights. That first generation of human rights being, what you would consider civil or political rights, the right to life, the right to speech, the right to equal protection under the law. Then you have this considered like this idea of second generation rights that have come a bit later, this idea that we have socio and economic rights, rights to food, right to housing, right to health care. And then this third generation of rights has really come about more recently, conceptually, in the last 30 or so years, this idea that we have rights, like sometimes they're referred to as green rights, the right to a healthy environment, and this right to a human right to a healthy environment. And so now, we can consider whether we're expanding things out, and we could either say that this is the rights of nature is the 4th generation, but really I don't think that's quite accurate because this 1st, 2nd, and 3rd generation has been of human rights. I think right now where we're at the beginning of this rights of nature movement in the United States and growing around the world is that I think where we're at is a 1st generation rights of nature, meaning that we're just at a place where we're just beginning to recognize that nature has the right to life, the right to exist. And I hope and I anticipate that as the work grows, as more laws are passed, as more constitutions are promulgated, that we'll begin to see an expansion of those rights of nature. So beyond the right to exist and thrive, regenerate, or be restored, I expect that we're going to see more rights recognized, 2nd generation rights, 3rd generation rights as well. And so I think we have a whole body of rights, legal rights, that are going to be down in the future, expanded and enshrined upon nature. And that's going to take quite a bit of time, I expect, of course, but the work has already begun. Part of that, I think, is right now, as many of you know, in the United States, that we have 36 or so communities that have now recognized the rights of nature on law. Those have come as parts of community bills of rights laws, and so they're part of laws that prohibit certain activities that would violate the rights of nature, and they're part of laws that also recognize the rights to self-governance and generally a human right to a healthy environment as well, but with that, the rights of nature. In Ecuador, as was mentioned earlier, in 2008, the Legal Defense Fund assisted the Constitutional Assembly in Ecuador in drafting constitutional provisions to recognize the rights of nature, or Pachamama, as they refer to it. And now we have the first cases that have now been decided in Ecuador. in which courts are finding violations of the constitutional rights of certain ecosystems and of species that have taken place. Many of you, I'm sure, are familiar with the Vilcabamba case, the Vilcabamba River case, in which road construction was interfering with the flow of the river and causing flooding and other kinds of damage, and the court found that was a violation of the rights of that river. And we've had other cases since then as well, in which you had, for example, shark hunting in the Galapagos area. And the court found that shark hunting, which they hunt sharks for their fins, and in any case it's quite brutal, that violated, in essence, the rights of the sharks under the rights of nature laws. And we've had other cases as well. And so we're seeing in Ecuador particularly, because it has it in its constitution, and we've seen cases being brought forward, that the courts are beginning to wrestle with, what does it mean that nature has rights, and what does it look like when nature's rights are being violated? And they're wrestling with that, but they're actually finding, indeed, that not only affirming the rights that nature has under the Constitution, but what violations of rights look like. And so we would expect that first sort of iteration of these cases, that the courts are going to be wrestling with it. Sometimes they find the rights of nature have been violated, sometimes they haven't. And very recently, you have the administration there under President Correa he's been very much opposed to the rights of nature. We've seen him do everything to open up Ecuador to more mining, more other kinds of extraction, oil drilling, and whatnot. You recently saw him within the last 2 or 3 months, that a new rule has been issued that under the rights of nature laws, people have the right to defend and enforce nature's rights. Nature has the right to defend and enforce its rights. The government has the authority to defend and enforce nature's rights. And that's the case not only in the United States and our local laws, but also in Ecuador's constitution as well. Well, now, in an effort to kind of push back, after we have a number of cases in which the courts have found indeed violations of the rights of nature in Ecuador, you have Correa's administration issuing a new rule which intends to prohibit people from actually being able to go to court directly on behalf and in the name of nature. And that is bringing rights of nature cases forward to try to restrict that, so that it's only the government, the national government, that has the authority to do that. So they're trying to restrict how the rights of nature are actually being used now in Ecuador. And we'll see how that plays out. It's very much what we would anticipate and what history teaches us, which is when you bring forward a new paradigm, you're going to see pushback on it. And we've seen the push for rights of nature, and now we're seeing this push back by the administration in Ecuador. The people are going to have to push forward again on it, and we're in discussions with folks there about it and what that looks like. And what's happening not only in the United States but in Ecuador as well, as this rights of nature work continues to grow, other countries are engaging, people in other communities in other countries, within organizations in other countries, and people who are working at the national level in their countries have approached us and have similarly recognized that their conventional environmental legal structure, which are very similar to what we have here in the United States, their environmental laws similarly work in a way to allow and permit and protect the very kinds of activities that are being found to be so destructive here are similarly exist abroad. And similarly, you see in other countries corporate rights, which are able to override environmental laws and efforts by communities to protect themselves from environmental harm. So you see a lot of parallels in our legal system with that in other places. And we've been working now in other countries like Nepal, which was mentioned, in which they have a new constitution which recognizes a human right to a healthy environment, but we are now working in Nepal and have been meeting with members of parliament for a number of years now to advance a rights of nature constitutional amendment specifically aimed at addressing climate change, where they have the Himalayan glaciers are melting and that's impacting species and people and ecosystems across that country. And so working with this group within parliament that are looking to advance a rights of nature constitutional amendment, and we'll see how that advances over this next year. In India, we've worked with groups there that have advocated for many, many years for cleaning up the Ganges River, and we worked with them to draft a national law to recognize rights of the river and the people of India to a healthy river ecosystem. That's been brought forward to Prime Minister Modi's office. He campaigns on cleaning up the Ganges River and hasn't really done much about it at all. But this rights of the Ganges has reached him, and he has different ministries within his government that are now reviewing the law and talking about the law and we'll see how that plays out. In the United Kingdom, we worked, as was mentioned, with the Green Party as they advance a policy platform on the rights of nature, and have had some conversations. What would it be like if they proposed a rights of nature law? I'm going to be in Sweden in April, and there's an Earth Rights Conference that's going to occur. I'm going to be talking about the rights of nature, and also, more importantly, holding a workshop in which people, activists from Sweden and perhaps other European nations, to come forward to really get into the meat of what is the rights of nature, how do we advance this in our own communities or in our own countries. Interestingly, in Sweden, you've had some members of the Green Party there introduce rights of nature resolutions into their parliament. So I'll be meeting with some parliamentarians while I'm there too to talk about what can we do to actually begin to advance this into law in Sweden. And so there's other work that's going on, and it's so interesting, of course, because it's hard to see a straight line from point A to point B to point Z with this work. And I say that because when we were in Ecuador talking with members of their constitutional assembly about what the rights of nature is, why they may seek to do it to protect the various fragile ecosystems of Ecuador, how it would empower people in a way that they aren't currently empowered under their environmental legal system. And they asked, where else has this happened? Where else has recognized the rights of nature in law? And at the time, we were really only able to tell them that some small communities in Pennsylvania have recognized the rights of nature in law, which was the first laws in the world, and to be celebrated. We didn't know, though, that would be, I guess you could use the word sufficient, to convince them that as a country they should move in this direction, but indeed they did. And that has helped energize the work, I think, in the United States as well, and, of course, opened up so many doors around the world for people to want to follow along this path. I think for many it makes a lot of sense that we cannot continue to treat nature as we've been treating it under the law and expect to actually protect it. And so that's not a straight line from smaller communities of a few thousand people to a nation. But we're seeing that happen. And the last thing I'll say is that we're also seeing now tribal nations beginning to move this forward. As was mentioned, the HoChunk Nation, which is based in Wisconsin, we assisted them to draft a rights of nature constitutional amendment to amend their tribal constitution. A first vote was taken on that in September, and I'm expecting that they'll be taking a final vote on that with a full tribal membership eligible to vote on that sometime this year, perhaps later this spring. It's not clear yet. And they'd be the first tribal nation in the United States to enact a rights of nature law, in this case a rights of nature, and enshrine it into their constitution. And that, again, not a straight line. We've talked with tribal nations for quite a long time in the United States and outside the United States, but they're the first. And that's opened up the conversation with other tribal nations. And that, I think, is very, very powerful. And I was speaking with a member of the HoChunk tribe just earlier this week. And, I said, we've been told that the rights of nature is in many ways a codification of indigenous values into law, into written law. And he said, yes, he agreed with that, but thought what I said was rather dry. Didn't have a lot of power behind it, and I would agree. And he said, for me, the rights of nature is about who we are as a people, who we were as a people, and who we will be as a people going forward in the future. Meaning that it embodies who they are and their relationship with what they call grandmother Earth. And that I found to be a very powerful way to think about it. And so we have peoples in all sorts of different contexts, all sorts of different countries at the local level, at a state level, at a national level, looking to advance this because they understand there's really something fundamentally flawed in our current relationship with the natural world, and that we need to not only change our individual habits and relationships to the environment, but that we need a fundamental restructure of humankind's relationship, and that means making fundamental change to our legal systems, which follows very much, I believe, in the footsteps of past people's movements who also saw fundamental wrong, fundamental oppression, and the need for real fundamental change in the existing structure of law. And they built movements to do that. And I think that's where we are, but I believe very much that we're in the infancy of this movement, that we're very young. We have quite a bit to learn, but that it is growing. And that I think is, I take great hope in that, that it is growing, and I hope you all do as well.